Welcome back to the channel Future CS. I hope your preparations are going good. So coming to this particular video, we'll be discussing about the penalties part. Sir, given the fact that law syllabus is very huge already, is it practically possible for me to study all the penalties given in the syllabus? So answer would be absolutely no, because it is not possible for you to study. Even though if you study all the penalties, it will be all confusing in the exam hall. So to make sure that you score all these 4 or 5 marks which are there for these penalties, we'll do one thing. We'll take some risk in the process and we'll study only few sections rather than leaving all the penalties as such. It is something but is better than nothing, right? So we'll study those penalties which are being usually asked by ICA for the past few many years now. So I've segregated somewhere around 10 to 12 sections which are regularly asked by ICA, out of which you will be seeing more often than not these four penalty sections: section number 127, section number 76A, section number 86, and 392. Yes, 392 comes from the foreign company chapter, which was usually the section 392 was regularly being asked by ICA at the final level. So expecting this might come from the inter level also, I've drafted that into the most important part. After these sections are done, then you can go to the remaining set of sections which are a little secondary priority, I can say. So these set of sections will come under the first priority for you. These are the most important penalties for you. After these sections are done, then you'll go for them as a second priority. So I'll leave a link in the description of this particular video, or I'll leave it as a comment. Go download this particular PDF. You'll get all the penalties at a particular place. Jumping into the penalties very quickly, we'll try to sum up them somewhere between 20-25 minutes, all the penalties combined together. So I'll be a little quick on the penalties part, expecting you guys to have knowledge about the background of these procedures already. So jumping into the video, section number 127. Remember, dividend chapter states that once the dividend has been declared, it has to be distributed within a period of 30 days. If it is not distributed within 30 days, the company will be punishable under section number 127, which imposes punishment on the company as well as a director. On the company, they will be imposing a penalty of 18% per annum simple interest. And coming to the officer in default, the director, they'll be imposing a imprisonment up to 2 years and a fine of rupees 1000 per day for each default. That means if the company has paid the dividend on 40th day, assuming the 30 day was a time limit, but the company made a default and distributed the dividend within 40 days. For those 10 days of default, I'll impose a penalty of 1000 per day, that is 10,000. So what is the imprisonment here? 2 years and a penalty of rupees 1000 per day. But what is more important in section 127 is the exemptions given under this section. What are the exemptions given under this section? There are 5 exemptions which states that in 5 different circumstances, even though company does not distribute the dividend within 30 days, company is still held not liable in the procedure. So give me the processes here. The first exception talks about the process called as operation of law. Because of any law, either it may be Companies Act or any other law for the time being, for that matter, which puts a restriction on the company not to distribute the dividend, and the company does not do so on the order passed by such law or any court or any tribunal, then it is not the default of a company, assuming there is succession law. If the person, if the member dies and there is no legal representative, amount is not transferred, or we'll apply the section 90 of Companies Act, SBO. If the NCLT passes an order to put restrictions on the shares, then also the company will not transfer the dividend. If it is not transferred within 3 days, it is still not a liability of the company, not a failure of the company, hence no liabilities. Second category, the key word is when there is a dispute. Say if a member dies and the legal representatives have a dispute regarding who will receive the dividend. In those cases also, it is not the company's fault to solve the dispute. Once the dispute is solved, I'll come and pay the money, but until that point of time, if the company is unable to pay the dividend, distribute the dividend, company is still not held liable. Third case is a little procedural part, where it states that the the shareholder has given certain directions to the company to how to dispose of the payment of dividend, and the company could not comply with those distributions, company could not comply with those directions, and the company has communicated back it to the shareholder stating that it was unable to comply it. So we have to satisfy 3 things here. The first thing, the company has received directions and the directions could not be complied, and after, because they have not been complied with, it is been the fact that they are not complied has been communicated back to the shareholder. Now, there are questions on this. If it is not communicated back, whether company is punishable in the case, yes, company is liable. It is not an exemption. It becomes an exemption only when it is communicated back to the shareholder. And the fourth exemption states that the amount of dividend which is payable by the company is a liability for the company. At the same point of time, company has something which is receivable from the same shareholder. Then company states that why to pay the money and receive the money separately? I'll do one thing. I'll adjust this money. Whenever there is lawful adjustment of amount of dividend with an amount which is receivable by the company, that may be either calls on shares, that may be either any contract entered by the shareholder where company has something receivable. Say company has given loan. Company can adjust that amount with the loan amount, etc. What is the key word to be remembered in this category? Lawful adjustments which are made by the company. And the last case is basically a residual part where it states that if the company has failed to pay the dividend, but the failure of the company to distribute dividend is not on part of the company, for some other reason company was unable to pay dividend, in those cases also where it is not due to the part of the company, then company is not held liable. So remember guys, section 127, penalties are important, but at the same point of time these exemptions are also very, very important for exam perspective. So moving on, the deposit chapter coming under section number 76A. 76A states that I'll impose punishments if you have contravened under section number either 73 or section number 76. What is 73? Prohibition on acceptance of deposits from public, and 76, acceptance of deposits from public. If the company has contravened any of those provisions under section 73 or 76 regarding the procedure for acceptance of deposits or regarding the process for repayment of the deposits or any interest upon those deposits, they will be punishable under section number 76A. Very, very important section which imposes punishments on two, the company as well as the officer in default. The company will obviously impose only with fine, where the company will be imposed with a fine of minimum 1 crore or 2 times the amount of deposits which are accepted, whichever is lower. That means this is only the minimum part guys. 1 crore or 2 times the amount of deposits whichever is lower is the minimum part. Maximum of rupees 10 crores. Coming to the officer in default, the officers who have made default under the provisions of 73 or 76 will be punishable with imprisonment of up to 7 years, a huge period of 7 years, or a fine of minimum 25 lakhs to a maximum of 2 crores. And during that default, if they had any wrongful intentions in the process and they have defrauded the depositors, they'll also be liable under section number 447. Quickly run through the process. The company will be imposed with a fine of 1 crore or 2 times amount of deposit, whichever is lower, as minimum penalty, and rupees 10 crores as maximum penalty. And the officer in default will be imprisoned for a up to a period of 7 years and a fine of minimum 25 lakhs to a maximum of 2 crores. And if at all they have done any wrongful activities, fraudulent activities, they'll be imposed under section number 447. Coming to section number 86. 86 is the penalty provisions for the entire charges chapter. The charges chapter ranges from section number 77 to 87. If you have made any contraventions of these provisions of the chapter charges, will be applicable for penalties under section number 86, which states that I'll not impose minimum, maximum, I'll impose a static penalty. On the officer in default, an amount of 50,000, and on the company, an amount of 5 lakhs. And if they have provided any false information, knowingly suppressed any material information, or submitted any false information while registering the charges under section number 77, they will be liable under section number 447 for fraud. Then section number 392. Section 392 is coming from your foreign company chapter, which is very, very important. For example, if there are 10 questions from this chapter foreign company, 3 to 4 of them are actually drafted from this section itself. So it becomes very important for you to score those 5-6 marks from the section. So what is this? 392 states that if a foreign company has made a default under any of the provisions of this chapter, chapter number 22, chapter number 22 ranging from section numbers 379 to 393A. If you have made any contraventions of these provisions of foreign company chapter, you will be imposed with penalties. The company will be imposed with a penalty of static penalty of 1 lakh to 3 lakhs. And on top of that 1 lakh to 3 lakhs, the foreign company will also be imposed with a penalty of rupees 50,000 per day for each such default after the first date. Assuming its process, if the company has made a default for 5 days, for the first day, I'll impose a penalty of somewhere between 1 to 3 decided by the court. From the second day, I'll apply the penalty of rupees 50,000. Imagine this, 50,000 per day. A huge amount of penalties imposed. And coming to the officer in default, he'll be imposed with a penalty of rupees 25,000 to 5 lakhs. So what is the penalties here? Company 1 lakh to 3 lakhs plus 50,000 per day, and officer in default an amount of 25,000 to 5 lakhs. These are the most important sections for exam perspective coming to penalty provisions. Moving on, some few sections, mainly section number 34 and 35. Yes, I agree. 34, 35 doesn't actually fall under the penalty provisions, but they don't have numbers, they don't have imprisonment periods, they don't have fine amounts, but they are penalty sections which are important for exam perspective. Coming to section number 34 first. Understand the difference first. What is 34? What is 35? So first, what is 34? 34 is thinking from the person who has done a fraudulent activity. I want to punish the person. For punishing such person, will impose him penalties, will impose him liabilities under section number 447. And section 35 talks about civil liability of a person who has made a for the misstatement in prospectus, which states that will collect, not pay damages, it is not pay penalties, but collect damages. It is thinking from the shareholders perspective who have incurred a loss. To protect those shareholders of incurred loss, aggrieved parties, I am collecting damages, compensation for those losses from the defaulting parties. And section number 35, I'm not collecting damages, I'm making sure that I'll punish them in such a manner that these kind of defaults are not repeated in the future. Coming to section 34, which states that, understand the wordings properly, where the prospectus has been issued, circulated or distributed with or without intention and includes any statement which is untrue or false, misleading, or any omission or commission which is likely to mislead. Understand the process here. They've used the word with or without intention. With or without intention means even though it is done non-intentionally, unintentionally, you're still liable under section. But it goes on, forwards the procedure and states that he is liable under section number 447. But 447 is something which is applicable when we apply the logic of fraud. That means it should be with intention. Then they come up with exceptions and state that if the same procedure was done believing that it was true, that means it was without intention. So the original wordings use the word with or without intentions. Later on, they remove that logic without intention by providing it as an exception, stating that if the person has reasonable grounds to believe, and he believed up to the time of issue of such prospectus that the statement was actually true, or that omission or commission of the statements was necessary for the shareholders, then it is exempted from liabilities. Otherwise, you are liable under section number 447. In a nutshell, you will be liable when it is intentional or unintentional. Absolutely. You will be liable only when it is intentional. Or if it was intentional, but the misstatement was immaterial in nature, for say, the company has a profit of say 10,45,000, 1 rupee. They have rounded off 1 rupee, 10,49,999.99, and they decided that they'll round this off and they'll mention 10,50,000. Is it material? No. Was it intentional? Yes. Are they liable? No, because it is an exception. They're not liable if it is immaterial in nature. Coming to section number 35, we'll be discussing that into 3 trenches. First thing, who is liable? Second thing, what has to be paid? To whom it has to be paid? Second thing is very easy. Whom? What has to be paid? We have to pay damages. How much damages, sir? How much ever suffering of losses that has occurred. If say loss is say 10 lakhs, I'll have to pay 10 lakhs. If the loss is say 15 lakhs, I have to pay 15 lakhs. Depending upon the amount of loss that has incurred, we'll pay the damages. And the third category, to whom, sir? The person who have suffered a loss because of your intentional misstatement in the prospectus. But the question is, who is liable? This is very important, guys. Who is liable? First thing, company. Along with the company, there are set of people who are liable in the process. We have a total of 6 people who are liable along with the company. So the answer starts with company, including the director, a person who is proposed to be appointed as director, a person who is named as director in the prospectus, experts, promoters, and any other person who has authorized the issue of prospectus. So walk through the procedure again. Come on, guys, you repeat it with me. A company, director, a person who has agreed to become a director, a person who has been named as such in the prospectus as director, experts, promoters, or any other person who has authorized the issue of prospectus shall be held liable. But there are exceptions. These people will not be held liable if the first exception, where the person has withdrawn his consent to act as a director. He's no more a director, he's no more a proposed director. He's not liable. Second case, where the prospectus document was issued without his consent or knowledge, and after knowing that the document was issued without his consent or knowledge, he has given a public announcement stating that the document prospectus was issued without his consent or knowledge. Hence, he is not liable. Third case, we as a person have given a statement relying upon the statement or a document given by an expert whom we believe to be competent. That means we have prepared a document which contains information based on the information mentioned by an expert. And we believe that expert was competent enough to provide the rightful information. And if it turns out to be wrongful information, our statement is also indirectly wrong. Have we done anything intentionally here? We believed that expert was competent. We believed that statement given by expert was true in nature. And we believing that expert statement provides something in our statement. We are not held liable if it is on the authority of an expert. That was your section number 34 and 35. I know there is no numbers, but they are very, very important for exam point of view. Then coming to section number 42, concept is simple. 42 is private placement, but will impose penalties only for the allotment procedure. Remember, once the private placement offer cum application letter is sent to the identified person, once he sends back the application form along with those monies, the company has two options, either allot or refund. If at all it is getting allotted, company has to file something called as written off allotment with the ROC. It has to be filed within a period of 15 days. If not filed within 15 days, company will be imposed with a penalty of ₹1,000 per day of such default, or ₹25 lakhs. A special provision, guys. Usually when this comes up, we use the word 1 lakh, but a special logic to be remembered specifically, 1,000 per day or ₹25 lakhs, whichever is lower for each such default. It is not for the entire process. For each such default, we'll be imposing an amount of 1,000 per day or ₹25 lakhs, whichever is lower, when company fails to file the written of allotment within 15 days. Remember, section 39 also has the same concept, written of allotment in case of public offer, where we had to submit the documents within a period of 30 days. Here we have to submit the documents within a period of 15 days. Moving on, section number 39. 39 simply states that allotment of securities, we can allot the securities only when we have received minimum subscription amount and we have received minimum application money. If both of them are received within a period of 30 days, we can allot the securities. Otherwise, we have to refund the money. If you have made any contravention under the provisions of section number 39, allotment of securities, you will be imposed with a penalty, similar kind of penalty, 1,000 per day or ₹1 lakh, whichever is lower. This will be the penalty under section number 39. Any default under 39, 1,000 or 1 lakh, whichever is lower. Then section number 92. It is again important, guys. It's been asked multiple times already. Section number 92. 92 annual return. As we know, annual return has two types of penalties. One regarding the certification of annual return, one regarding the filing of annual return. Coming to the certification part, the annual return is required to be certified only when the company is either listed or it is a company, guys, not a public company having paid up share capital of more than equal to 10 crores or a turnover of more than equal to 50 crores. What are the limits here? Either the paid up share capital of 10 or turnover of 50 crores. If company satisfies any one of these limits, they have to get their annual return certified, verified by a company secretary in practice. And if the company secretary in practice in this procedure provides a false certification, provides a wrongful certification, then he will be liable with a static penalty of rupees 2 lakhs, with an amount of how much? Static penalty of 2 lakhs. Coming to the second part of the penalty of section 92, filing of annual return. Once the annual return has been prepared and signed, it has to be approved in the general meeting. Once it is done, once the annual general meeting has been conducted, it has to be filed with the ROC. It has to be filed with the ROC within a period of 60 days from the date of AGM. And if the AGM is not held, it has to be filed within 60 days from the last date on which AGM should have been held, along with the reasons of not holding the AGM. If the filing of such annual return has been defaulted, that means it is not filed within the 60 days respectively, then they will be imposed with penalty. A special type of penalty here, the company and the officer in default, company, a static penalty of 10,000 plus rupees 100 per day, subject to a maximum of 2 lakhs. Understand this? 10,000 is separately imposed. Then on top of 10,000, I'm gonna impose a continuing default of rupees 100 per day, but subject to a maximum of how much? 2 lakhs. Same concept for officer in default, but that continuing penalty is subject to a maximum of 50,000. What the penalties here? First penalty section would be 10,000 plus 100 per day up to a maximum of 2 lakhs. This 2 lakhs limit is for whom? Company. And the same logic. For officer in default, penalty will be 10,000 static penalty, then 10,000 per day up to a maximum of 50,000. So 2 lakhs and 50,000. That's your section number 92. Make sure that this is done before the exams. Very, very important. Then the slightly more important sections, but they have been asked a couple of times in the exam. So coming to this, section number 121. I'll go quick on this. You remember section 121 is called as report on annual general meeting. So whatever happened in the annual general meeting will basically summarize everything into a document and submit it to the ROC, and this logic is applicable only to listed companies. And this is prepared in addition to the minutes under section number 118. So 121, report on annual general meeting. It has to be filed within 30 days from the conclusion of the AGM by all the listed companies. Sorry guys. It has to be filed within 30 days from the date of conclusion of the AGM. And if the company fails to submit this document within 30 days, there comes the penalty imposed on the provision. So when is the penalty imposed? When the company fails to submit the document within a period of 30 days from the date of conclusion of the meeting, where the company will be imposed with a penalty of how much? 1 lakh statically and rupees 500 per day for continuous default up to a maximum of again 1 lakh. So what's the penalty here? 1 lakh is the static amount and rupees 1,000 per day up to a maximum of 1 lakh, whichever is lower. Then the last couple of sections, let's complete 33 first. What is 33? Abridged prospectus. Now the concept of abridged prospectus is simple. Companies Act simply states that whenever you are inviting people for subscription of securities, along with the application form you send them, you must be always accompanying another document called as abridged prospectus. If application form is sent, along with application form, I should always send my abridged prospectus. If application form is sent without the abridged prospectus, for each such default, each such application form sent without abridged prospectus will be imposing a penalty of rupees 50,000 per default. Rupees 50. And imagine this, company would be sending lakhs and lakhs of application forms. For every application form without abridged prospectus, I'll impose 50,000. But there are exceptions. There are 3 exceptions. When the securities are not offered to the public, that means it is a private placement, there is no requirement of prospectus. Or when the securities are offered to the existing members, they already know about the company. I'm not required to introduce about myself as a company again to my members already. Then third case, when the securities are offered under a underwriting agreement, underwriters already know about the company, they have done the research before they be appointed as underwriter, and there is no requirement of intimating it to the underwriters. When it is not offered to public, when it is offered but offered to the existing members, or it is pursuant to an underwriting agreement. There are 3 exceptions where the application form is sent even without the abridged prospectus, there won't be any penalty. But usual concept is if it is not sent with the abridged prospectus, will impose a penalty of 50,000 per each default. Then Section number 447. You remember section 447 is now divided into two categories: the cognizable offenses and non-cognizable offenses, right? Cognizable, or you can say, compoundable and non-compoundable. Compoundable, I can compromise on the imprisonment part. Non-compoundable, I'm not allowed to compromise, I have to impose imprisonment. The compoundable part applies when the amount involved in fraud is less than 1% of the turnover or 10 lakhs, whichever is lower. If it is within this limit and not involving public interest, we'll be imposing a fine of rupees up to 5 lakhs or imprisonment of up to 5 years, up to 50 lakhs or up to 5 years or both. So what's the provision here? If the amount involved in fraud is less than 1% of the turnover or 10 lakhs, whichever is lower, will impose a imprisonment of up to 5 years, fine of up to 50 lakhs or both. Or if the amount involved in fraud is exceeding that limit or it is involving public interest, will impose a second category where it will be divided into two categories. If it is not involving public interest and involving public interest. If it is not involving public interest, they'll be imposed with the imprisonment of minimum 6 months to a maximum of 10 years. And if it is fine, coming to fine part, they'll be imposed with a fine of minimum the amount involved in fraud. Remember the words amount, not, it's not amount of fraud, it is amount involved in fraud. Amount involved in fraud or the 3 times the amount involved in fraud. When, if it is involving public interest, the minimum imprisonment increases from 6 months to 3 years to a maximum of 10 years again, and fine of amount involved in fraud and amount 3 times the amount involved in fraud. If you compare both the provisions, what's the only difference you'll find is minimum imprisonment. Minimum imprisonment if it is not involving public interest, 6 months. Minimum imprisonment if it is involving public interest, 3 years. Rest would be the same procedure. The last provision, section number 147. If the auditor has made contravention of the provisions of this auditor's chapter 10 of the Companies Act, then they'll be imposed with penalties. There are 3 hierarchies here, guys. We'll separate them and read them individually. First thing, on the company. Second thing, on the auditor if it is unintentional. Third thing, the auditor if it is intentionally done, intentional default has been done. Coming to the company part, the company will be imposed with a penalty. The company will be imposed with a penalty of minimum 25,000 to a maximum of 5 lakhs, and office in default with minimum of 10,000 to 1 lakh. A company with an amount of 25,000 to 5 lakhs and officer in default of 10,000 to 1 lakh. This is on the company if they have made any default under the provisions of Auditors chapter, section numbers 139 to 148. Then moving on, auditor if it was unintentional in nature, he'll be imposed with a penalty of minimum 25,000. Understand this, we'll divide this into two categories, guys, for our easy remembrance. If it is unintentional, I'll impose only one thing, fine. If it is intentional, I'll be imposing 4 different kind of punishments upon him: fine, imprisonment, asking him to refund the money, and asking him to pay damages. Repeat after me. If it is unintentional, we'll impose only one thing, fine. If it is intentional in nature, the auditor will be imposed with 4 different punishments: fine, imprisonment, refund the remuneration, and pay damages. Coming to the unintentional part, fine. A fine of minimum 25,000 to a maximum of 5 lakhs or 4 times the amount of his remuneration, whichever is lower. What is this? 5 lakhs or 4 times the amount of remuneration, whichever is lower. Coming to the second part, if it is intentional in nature, it will be imprisonment up to 1 year, fine of minimum 50,000 to a maximum of 25 lakhs or 8 times the remuneration, whichever is lower. He has to refund entire amount of remuneration collected by him as an auditor and pay damages to the members or the creditors or to the company for providing a misleading auditor's report. For providing a misleading report, he has to pay damages. And these are the important, guys. You'll usually get confused in this process. What is this penalties here? If it is unintentional in nature, we'll impose how much? 25,000 of minimum penalty, 5 lakhs or 4 times the remuneration. If it is intentional in nature, 50,000 to 25 lakhs or 8 times the remuneration, whichever is lower. So that would be your entire penalties which are required for exam. try to remember them, try to watch this video multiple times or revise alongside me when you are watching this video, so that it will be easy for you to bifurcate. And what would be the most important part? The first page. So I've given them in a hierarchy itself. What are the important parts? I've not given them like section in the order wise of sections, but I've given them in order wise of priority for exam purpose. So make sure that you're reading from the top every time you read it, right? So these will be the penalties which are important for exam. Make sure that your preparations is going on point. These will be the penalties. These will be the sections which you study after you're done with the content part. Obviously, which is more important, guys? Content, not the penalties. So penalties will be additional part, right? We'll see you in the next video. Hope your preparations are all going good. For kind of some updates and etc., I'll upload this video as well as the document also on the Telegram channel. Join the Telegram channel for more updates on this. Thank you, guys.